Appellant.
Lords, my lady, I propose, just to give you a very brief outline of where I'm going to complete, it may be helpful, I propose to complete the observations I've got on the authorities, but as part of that I'm going to deal with the Court of Appeal's interlocutory judgment in the case of Balwah and Abdulla. But thereafter I'm going to go in some more detail than my learned friend Mr. Strang went in looking at the sequence of events from the beginning in respect to the pleadings and the statements and so on, and then I shall deal with the matters which arise between us. The trial for this matter was set for the 5th of June 2017. And shortly before trial, it became apparent to us, if I may include myself because I was involved in this, that the reports that were relied upon by the defendant, in particular from Dr. Wilkinson, the pediatric neurologist who also served as an expert in neuroradiology, that the report of a scan, which was done locally on the 19th day of birth, after birth, CT scan, was reported as being normal. And much reliance was placed upon this by Dr. Wilkinson. I'm giving you context before I deal with the application and how it was dealt with by the Court of Appeal. Much reliance was placed upon the normality of that scan as evidence that the injury had occurred much earlier than close to, namely the intrapartum period. And so it was that we decided that we should look at this scan. There was a practical difficulty because it was a photographic scan. It couldn't be copied. It had to be couriered to England to be seen by our expert and back. But shortly before trial, we had a report from Dr. Forbes, who was our neuroradiologist, who said that no, it's abnormal. So we needed, at that stage, to be able to call before the court his evidence as to its abnormality, and we needed to be able to look at our pleadings in relation to it. This was mentioned when there was a pre-trial review before the judge, and it was drawn to his attention at that stage. Mr. Aeden Balwah, senior counsel, was instructed on behalf of Dr. Abdulla, and understandably simply said he couldn't deal with it at that stage. And the upshot of it was that the judge decided to adjourn the trial for the application to be made formally. And a formal application was made. It was heard before the judge, and he determined it. And, my lords, you will find that application being dealt with in the interlocutory judgment of the judge, which is at page 133.
Could I interrupt you at this
yes,
point? Forgive me. Permission was given to amend by the judge, as I recall.
Yes.
And the Court of Appeal reversed that.
That's exactly right.
Yes.
And the reason...
Can you tell us how it's relevant to the issues that we have to decide?
Yes. It's enormously relevant. It's probably one of the most relevant issues to the issue of the amendment. It's relevant because of this. The scan evidently became important to both parties. We needed it to be admitted into evidence with an expert report. Although there's some dalliance before the judge as to whether or not this was necessary, of course we thoroughly recognized that it was necessary to make a formal amendment. The judge went through the process of 20.13 and 3A and determined in the end that the only sensible way, effectively, was to grant us the amendment. But the Court of Appeal ruled it out. And it's probably not necessary, but I just simply invite you, when you retire to consider this matter, that you read the brief judgment of the trial judge in this interlocutory matter, and you read the few pages on which we strongly rely of the attitude of the Court of Appeal in respect of late amendments. And the importance of this was not only that the Court of Appeal reversed the finding of the judge, but the importance of it was that it was done in the face of what the judge himself had recognized as the only proper way of dealing with it. That in order to get it, to be able to manage this case, this importance of the scan needed to be considered by the court. But it was too late, as the Court of Appeal found, that it was going to disrupt the administration of justice, it was going to pull the rug from under all the preparation that the defendants had done right up to the point of trial on the basis of this scan being abnormal. And that managed to persuade the Court of Appeal that notwithstanding the hard nature, as they recognized, of refusing that amendment, that the amendment would not be allowed.
At that time, you accepted before the Court of Appeal that the amendment would introduce a fundamental change in the plaintiff's case.
Absolutely. Absolutely.
And that was the basis upon
which... Yes. I mean, my learned friend who has found something else to entertain him rather than being here with me as senior counsel, as you've heard from Mr. Strang to begin with, because he is engaged in something else, plainly gave way to what was being presented to him by the Chief Justice and the other Justices of Appeal, that it was effectively fundamental to the case and it was going to pull the rug away. And despite all the merits of it being entertained by a trial judge, the Court of Appeal refused it on the basis that it was going to be disruptive to litigation. And when it comes to addressing the point of justice, and this is a very important point, what the Court of Appeal did was to say justice has to be subordinated or looked at in the greater context of the organisation and the proper conduct of proceedings. And even though that meant that come to trial, it was not going to be possible for this evidence to be admitted.
What's the page number for that statement? What's the page number for the Court of Appeal's assertion that justice has to be subordinated to pragmatism?
Give me a second. The judgment itself, as you know, starts at page 179. And the relevant pages probably are the Chief Justice recognising that there was a specific omission, that is page 151 in your bundle. And the acceptance by the Chief Justice on page 154 of Mr. Logan's submissions of it undermining the substandard of the case, that we'd known about it all the way along, and finally on page 157, and in particular, in answer to your question 158, where the Chief Justice says, outside a certain empathy for the very unfortunate outcome for the infant, this really flies, as Mr. Logan says, in the face of all the principles of case management that this court has repeatedly articulated. Hard cases sometimes make bad law, but this is, we are afraid, we're being encouraged to make a very bad precedent here. So this was...
Sorry, Dr. Powers, could you make sure you...
I'm so sorry. Despite reading that notice many times, I should have done that. I hope you've heard my submissions at least, my Lord, on 158. Now, the implications of this is that despite it being advantageous to us in making the amendment, and indeed to the court, as the court had accepted, what happened here had to be subordinate to the manner in which cases were conducted, despite the fact that this obviously important piece of evidence could not be dealt with, even with adjournments and costs and all the rest. That didn't matter. What mattered is that the proper order of cases in Trinidad needed to comply with the rigours, as we put it, of the process of amendment. And my Lord...
So just so I fully understand,
I'm so sorry.
The change was that there was a CT scan which showed abnormalities in the brain.
That's right.
And there would have been sufficient time for people to form their own views as to which CT scan was correct. And there would have been an opportunity for people to then take that on board.
Almost correct, my lord.
4 days before the trial.
Yeah, but the trial was adjourned. Was it?
Yes.
The trial was taken out of the list, is that right?
It was taken out of the list
Yes.
because at the 11th hour, as was pointed out,
Yeah.
we produced a new piece of evidence, which the Court of Appeal in the end said, well, we could have done this years ago.
Yeah.
So even though, I'm not looking at the merits of whether or not it should have been done, even though it was recognised that this was a critical piece of evidence, and there were difficulties in getting it and all the rest of it.
Yeah. Okay.
But in the end, the discipline by which the cases should be conducted had to prevail over the obvious merit of the consideration of that defence. It's not a complaint that's made. In fact, I pray this in aid of the attitude at the time in 2017, which in our submission is still the case, so far as the courts in Trinidad are concerned, when looking at the rigour within which the rules are applied to amendments. In
You
the
say
end,
what source for the goose is source for the gander.
yes, yes.
But in the present instance, the witness statement of Dr. Abdulla had made clear, had it not, at least 2 years before any question of amendment was raised, what his position was in relation to the timing.
Yes, and if you will forgive me, I suspect that you will hate me for saying so. I'd like to deal with that in the course of the chronology now.
Will you mistake things in your own?
Yes, because so when the upshot of this was, of course, the trial was adjourned and came back to be tried. And in the interim of somewhere near a year, as I'm going to unfold to you in the chronology, it became apparent that both sides needed to consider this scam, but of course it couldn't be brought before the court. And then as spurious, on day 6, it was finally sorted out the only way it could be done, because the Court of Appeal had imposed the framework of the admissions, that it was normal, was not for us to repeat the process because we'd already been defeated, but for Dr. Abdulla to make an application to change his defence to accepting that the scan wasn't normal, and for us, therefore, to change our reply to accept that it wasn't normal. And therefore, it became part of the evidence in the case. The only way that could be done, the only way in which that could be done, was by changing the pleadings. Because until that had been done...
Bizarre that a case... Well, to me, it seems totally bizarre that a case could proceed on a false basis that flies in the face of CT scans that become available.
Yes.
I just, at the moment, anyway, not to worry. It's okay.
Yes.
Well, it was one CT scan, but with different interpretations. Am I right?
In the end, not entirely.
No.
But the radiologists, effectively on both sides, when they looked at the original, the only copy,
Yes.
they both agreed that it was abnormal.
Yes. But it was the
Then the subsequent
one taken on the 6th of June, which had been reported as normal. Then your expert said, actually, no, it's abnormal. And then you're telling us that Dr. Abdulla, rather than...
Well, his expert himself.
Yeah, but rather than relying on the earlier interpretation, came round and accepted that it was abnormal.
Yes, and then there was a slightly different interpretation of what that abnormality
Yeah, or,
There was a joint report
Yes.
dealt with it, and there was a common ground. There was abnormality, but there were different interpretations
As to what?
as to the extent of the abnormality.
Yes, and that's why when I come to deal with it, I'll deal with it more quickly because you've raised it. The CT scan, which could have been a discriminator as to whether this injury was prepartum or intrapartum, fell away. Because Dr. Wilkinson's evidence, to begin with, accepting as we all did that the scan was normal, relied upon it as almost definitive evidence that this could not, therefore, have been an intrapartum injury. The mechanism behind this is that if it had been much earlier, the inflammatory process and the death of neurons and so on would resolve itself such that the scan effectively, it's not a high-definition scan, would become normal. And therefore, the normality of the scan at day 19 was inconsistent with the and with an intrapartum event. But then he had to change his mind, which he did in that joint statement, my Lord, which you've made reference to, with a slightly different interpretation of what it meant. But it also meant that the CT scan no longer became a discriminator in the case. And that was very important, given that what the judge...
You were able to get round the Court of Appeal's findings, ruling, and you no longer had to proceed on the basis that black was white and white was black.
My Lord, that's quite right. And of course, it was a sensible way to do it.
Yeah.
But the point won't have missed you, of course, that what had happened to the parties is that both of the parties were constrained by the state of the pleadings.
Well, the point won't have missed you either, that the Court of Appeal might have been wrong.
Well, that comes to the issue of justice, which I shall deal with, because essentially the authorities which the other two I'm going to take to are the Loveridge and Healy case and four phones for you, very briefly. Because the essential submission on the law is this, that in Trinidad, the present law is that there should be no deviation or derogation from the pleadings, even if there's an argument that justice would accept it, and even if there's an argument that there won't be any prejudice by doing it. Now, that seems a remarkable statement to make, but that is a statement which I make as the state of play on the way in which the Trinidadian law is enforced by the courts in that jurisdiction. It's different in this jurisdiction. If we look at the case of Loveridge, which is the next authority, which you'll find on 2973. Mr. Sprang referred to this, so I don't need to do anything other than just read a little more into it, because in my submission, his interpretation of Loveridge differs from the one which we would suggest is the correct interpretation. It was subsequently looked at and commented upon in phones for you, but perhaps we can just actually look at the passages to which he'd drawn your attention, which you'll find on 2981. Now, this is, of course, a judgment of the then Master of the Rolls, Lord Phillips, in 2004. So it's 22 years old. And that's relevant to the way in which the law has developed since this time. To pick up the points which Mr. Strangford relied upon in paragraph 24, the recorder was not bound as a matter of law to disregard the admission made by the defendant because it could be demonstrated that the facts admitted were not true. He had to decide, having regard to all material matters, it would be right to permit the facts admitted to be put in issue. Now, what unfolds in the next couple of paragraphs, down to paragraph 27, which we'd invite you to read again, is not whether or not the facts can be put in issue, but whether or not the facts which have been raised are sufficient for the need to have an amendment. Because if they are put in issue, they needed to be pleaded. And that's apparent in this judgment of the Master of the Rolls. Let me just take you to the relevant parts of it. Just the last sentence of paragraph 24, more pertinently observe that the issue of whether permission should be given to amend the defence had not been argued, and that it would be wrong to proceed on the basis that the recorder had ruled it out. And then I agree with Mr. Blum. The recorder was wrong to hold that as a matter of law he was bound to find that the notice required by schedule had not been served. Until the defence was appropriately amended, that issue could not arise. This is a recognition by the Master of the Rolls that there was an issue of importance and that it couldn't arise until the defence had been amended. And furthermore, to address my Lord Jones's point, because there's a degree of embarrassment, I suppose, speaking on my own behalf when it came to the then claimant's witnesses being cross-examined, contrary to the pleaded case, that I didn't more forcefully and immediately say, this can't go ahead unless the case is amended. But it has to be looked at. It really has to be looked at in the light of what was happening in the case. I'll continue this section in a moment, but it's relevant here. On the first day of trial, it was recognized by all the parties, by the judge, by Mr. Abdullah's counsel, and indeed by the clinic's counsel, that this situation needed to be resolved as regards the scan, because we'd all be trapped in this ridiculous situation. And that process of resolution went on for about 6 days, during which the scan was finding its way backwards and across the Atlantic and being put in front of experts at the last moment to see if, as Lord Doherty has mentioned, they could jointly agree something. But it was recognized almost on a daily basis, and certainly on the very first day of trial, which was Thursday the 14th of March, when all these issues were deliberated upon, and we've made reference to them in our written submissions, that no evidence at all could be adduced in respect to the abnormality of the scan until the pleadings had been amended. Indeed, Miss O'Rourke went so far as to say, with which we didn't disagree, that any reference to an abnormal scan by any witness would have to be struck out of the records, because it was not part of the pleaded case as it stood. And it was only after the amendments were agreed on the 6th day, which I shall come to when I go through the chronology, that the court could process the scan. Now, the reason for its importance, my lord, is that it's an exactly comparable situation to what happened with the pleadings as regard the 4 to 5.
Well, it's not exactly comparable, because in the one case there had been a motion, well, there had been a motion to amend, which had been refused. You didn't have that here.
No, but it's relevant. It's relevant in this fact. That's why I said earlier that if an application is made to amend and it's refused, it suddenly becomes crystallised that you can't step outside.
I just wondered about the Court of Appeal's decision. Imagine if the case had proceeded on the basis that the scan was perfectly normal.
Yes.
And everyone knew that it was abnormal.
Yes.
How could counsel advance that case? How could a witness, a medical expert witness, base anything on that proposition? Doesn't that just demonstrate, unfortunately, that the Court of Appeal fell into error? You just couldn't run the case with people abiding by their professional obligations to the court.
Well, counsel recognised this. That's why, in the end, we got around
the ruling
of the Court of Appeal.
Yes.
But the underlying point, my lord, which I'm sure I've said before, forgive me for repeating it, is that until the pleadings were changed, it could not be dealt with. It could not be dealt with anyway, because the pleadings had to be changed. And our point is that they had to be changed in respect of the timing as well, because when the timing issue arose, I appreciate I've got to deal with that, when the timing issue arose, which we say it did through cross-examination for the first time, cross-examination against pleaded admissions, and when objection was raised to that.
Well, it had been raised before that in the witness statement, to which no objection was taken to this relevant part.
My lord, I shall certainly, with pleasure, deal with that.
I'm sure it's just when you said it's raised.
Yes, I'm very conscious. I can deal with it immediately on the basis that the witness statement was in conflict with, continued to be in conflict with the amended pleadings of the second defendant on timings. Now, this is a general submission that in a case where a party advances through a witness statement, an amendment effectively to the pleadings which are not amended, that as a matter of procedural law cannot be permitted unless two things happen. One of two things happen. One is that there is an amendment to allow that, because otherwise there's a conflict between what's being advanced as against what's being sworn to be accepted. And it can't be advanced, obviously, in cross-examination against witnesses who are giving evidence which is completely in accord with admissions made by the defendants. So that's one thing that can't be done. The other, which might arguably be done, is to deviate from those pleadings in some circumstances in which it may be permissible to do it, where the interests of justice may demand it, or where the issue of prejudice in respect of the party against whom those pleadings are amended can be overcome or is insignificant. Now, what happened in Loveridge was that there was a requirement to amend. This is in 2004, a requirement to amend to pull it into line. It wasn't a deviation from the pleadings. It was an example of when the issue became important enough for the pleadings to be amended. And the process of that is obviously important simply because the process of amendment creates the justice of whether or not in all the circumstances there should be an amendment, which means the court has to regard first those two threshold elements of good grounds. Well, there obviously wouldn't be in a situation like this, or promptitude. There obviously wouldn't be in a situation like this on either the scan or the timing. So the case, were an application to have been made to amend, which is what Mary O'Rourke on behalf of Dr. Abdulla persisted in recognizing was necessary, and which the Court of Appeal also noted as a matter of importance was never made, in our submission would never have succeeded because it would have failed on the threshold grounds. And that's why in our submission it was never made. Because if it had been made, then the case would have crystallized in the way which would have stopped all of the evidence related to 430. It would have stopped the cross-examination on 430. It would have stopped expert evidence being given on 430.
Or would it, given the re-amendment by the first respondent? You say the amendment would never have been allowed, but it was allowed in relation to the first respondent, and indeed wasn't substantively opposed by the appellant.
Yes. And in the circumstances, the objections which I raised to that, to the Court of Appeal, were ill-founded. They were ill-founded on the basis that because there was an agreement between the parties in respect to that amendment, which was done at the same time that Dr. Abdulla and Aeden were sorting out how to deal with the scan. It was all dealt with on day 6. There was an amendment made by the first defendant, the clinic. At the time, I didn't oppose it, but not opposing it, as the Court of Appeal quite rightly pointed out, was effectively acquiescing to it. And in fact, on the very same day, as one has to accept, the amendments that were made in respect to the pleadings on the scan were all done by agreement. So it was a bad point to be raised. My excuse for raising it is simply that, unlike the provision in English amendment, where there is a provision for the parties to agree, there wasn't a similar provision in Trinidadian procedural law. But
what's the impact, then, of the permitted amendment in relation to the clinic?
Yes.
Would the judge have been able then to say, well, I find that the second stage of labour started at 4:30 p.m. and lasted until 5:30, 1 hour, and that didn't leave 1 hour after it before the caesarean section. And therefore, there's no causation found against the clinic. But unfortunately, I'm bound by the pleadings of Dr. Abdulla, and I have to make completely different findings in relation to him. Is that the case you're seeking to advance?
No, because what you're proposing, my Lord, is something which is plainly not sustainable by way of argument.
Why not? If it was open to the clinic to argue that second stage of labour commenced at 4:30, that's on the amended pleadings.
Yes, but it wasn't open to Dr. Abdulla without an amendment to adduce evidence. And bear in mind, this is a situation where the clinic has not called any evidence which is contrary to a 4 o'clock timing. Every one they called was a 4 o'clock timing. They could have done it through cross-examination.
Well, they did rely upon the medical notes.
Yes,
I mean, that was the basis of the pleadings.
yes,
I
but
understand.
each of the experts that were called on behalf of the clinic had interpreted what was written, and this is a question of interpretation. And so far as Dr. Abdulla was concerned, his interpretation varied at different times as to what was meant, whether, for example, as he put in his amended defence, whether there was, he was called at the time when there was full
I do
documentation.
apologise.
So,
Was it open to the trial judge to have found, insofar as the clinic was concerned, was it open to him to have found, as far as the clinic was concerned, that the second stage started at 4:30?
the straight answer to that is yes,
Yeah.
but the underlying explanation, and this is equally important, my Lord, is that the evidence couldn't be called by Dr. Abdulla, who was bound to his own pleadings, by witnesses who were going to say it was 4:30.
Well, couldn't the clinic cross-examine him? I mean, if you had succeeded in closing off his giving that evidence in chief, surely the clinic would have cross-examined him to support their case.
And the clinic did at
Yes.
page 2107 and 2108, where that evidence was elicited.
My Lord, the evidence in our submission couldn't have been called by a defendant who had admitted one thing and wanted to adduce evidence contrary to those admissions.
But it was elicited without objection in cross-examination of Dr. Abdulla by the first respondent.
And in addition, the evidence upon which the judge relied were the medical notes and records. And that was admitted by agreement, as far as I understand. The evidence upon which the judge comes to his conclusion is the medical notes and records.
In the
And
end,
there was no objection to the admission of that evidence. In fact, everyone relied upon it, as far as I know.
yes, in the end, the judge had to abandon his reliance upon anybody in the interpretation of 4 or 4:30. The point I'm seeking to make isn't that within the scope of that amendment, and the amendment just formed just two particular passages. One was shortly after 4, Dr. Abdulla arrived, and that's consistent with the original pleading. And the other was the assertion that there was an hour before 5:30, not the hour before 5:30, but it gave that flexibility up until 5:30 for the clinic to be able to assert something in support of that pleading, to be covered effectively. But as the Court of Appeal noted, they called no evidence in support of it, and I appreciate what Lord Burnett has been saying about this, but the situation would be different because one party, every party has an obligation under the rules of procedure to set out exactly the facts and matters that they rely upon. And it would be a strange proposition, I would respectfully submit, that if the court were to say that one defendant had made an admission, that it would mean that another defendant could somehow conflict his pleadings with his evidence. Just because one defendant has admitted or denied something doesn't permit the other defendant to both at the same time plead an admission, as happened here, and at the same time adduce evidence which is contrary to that admission.
But doesn't it come back to Lord Stephen's point that if the judge has sufficient material before him to make a finding of fact on 4 or 4:30, 5 or 5:30, then the judge has to make that finding. And once you've made a finding in fact, it has to apply consistently. So the only issue is whether there was sufficient material before the judge to entitle him to make the finding that he did.
Yes. Well, milady, of course I accept that. The difficulty is what would have happened to the evidence if, in our submission, Dr. Abdulla, that was running the causation element through Dr. Sinkhorn and Dr. Wilkinson, what would have happened to that evidence if, contrary to his own ambitions, he could not adduce it and rely upon it, which was exactly the proposition which was put forward by his counsel in respect of the scan. And in the end, the justice of the situation is that the scan held Aeden to the pleaded admissions, because ridiculous though it was, that's what the Court of Appeal decided should be the case. That is what was necessary to control litigation. And yet when it comes to the, I'm going to call it deviation from the pleadings that happened during the course of the cross-examination for the first time, I'll come and deal with the statement in the chronology. When that happened for the first time, that was when there was first put evidence before the court that conflicted with the amendments. Now, may I just very briefly, I don't want to be deviated too much from plainly pertinent questions which you're asking, milady, about it. But my proposition is that Loveridge and Healy does not allow a deviation from a pleading. It requires the pleadings to be amended. And when it came to the consideration that was given by this, by Lady Falk in the judgment of Phones for You Limited, you may wish to look at the review of this case, which was decided only last year in the Court of Appeal. The relevant part where the law is reviewed runs from page 3023 through until
3023.
3023 through until the end of 3025. I can summarize it this way. There was plainly a recognition that there are circumstances in English law where there can be deviations from pleadings, where effectively the interests of justice apply, and where there is no prejudice to effectively the losing party. But otherwise, parties are held to their pleadings until such time as they amend them. The issue, as I hope I've managed to convey to you, is that this is not the state of the law in Trinidad. The pleadings predominate over justice. If there's a justice point, it is determined by amendment, because that is the way in which the courts can consider whether it is just to allow that course to be followed. It is not determined as a consequence of saying, well, there are some circumstances in which you can deviate from the pleadings, because that is not the law in Trinidad. And the acceptance and the development, as it is, in the case of Phones for You, of the ability to migrate away from the pleadings is done as perhaps laws becoming more acceptable, in the sense that in the end what the courts seek to do is to do justice between the parties as long as there's no prejudice, or if there is prejudice it can be offset one way or the other. That is not the situation in Trinidad. And it's not the situation in Trinidad because of this reason. The incorporation, which happened as a consequence of Bernard and Sibalak, of the discretionary element in Rule 21(3)A, enabled the courts to exercise discretion, but only after the threshold criteria of reasonable explanation and promptitude have been crossed. It has, in our submission, in Trinidad, still now, as the law is, it still has to go through an amendment process. And the amendment process itself will then determine whether or not, in the justice of the case, there should be an amendment. That's the whole purpose, after all, of the amendment rule, is to determine whether or not it is just in the interest of justice for that amendment to take place. It's the means by which it is tested. And if it doesn't fulfill that task, then the amendment isn't allowed. So in short, the justice and prejudice point have to follow through the process of amendment. It can't be a collateral, it can't be an aside. You can't have a fundamental issue, and there is a fundamental issue here. The fundamental issue is timing.
Just wondering, in relation to 2875 and the threshold criteria, it refers to a good explanation rather than a good reason for the change not having been made prior to that case management conference.
Yes.
And the application to make the change was made promptly. So the first point is good explanation rather than good reason. And the second is, I wonder whether or not in interpreting, in construing those threshold requirements, one keeps in mind the need to do justice between the parties. And I was wondering whether there is an overarching consideration. Is there any overarching principle as far as to be found in the rules that might bear on how that is interpreted?
Rule 1, not in similar terms.
Yes. Yes.
Well, good reason and good explanation. What's the difference between the two?
What you're suggesting, my lord, is should the overriding principle affect the interpretation of the rules?
Yeah.
And if that is so, then one looks at the overriding principle and says, well, you know, what's the justice of the situation?
Yeah.
And if the justice of the situation permits, then there's no, if the justice of the permission is accepted, there is still the next hurdle of promptitude. Right. Because even if the first rule were to be passed on reasonable explanation, it would fail on the second rule.
And does promptitude take its colour and character from the circumstances of each individual case?
Well, inevitably that must be the case, but we're not talking about days or weeks, because even in this case itself, the trial judge, in giving his judgment, did manage to rule that despite the fact that we had known about this scam being normal for a long time and bothered about challenging it, that we had nevertheless been sufficiently prompt, just days before trial, in getting but of course that was overruled by...
I sympathy with you. You had been provided with some evidence that you were finding difficulty about analysing.
Well, in short, yes, of course, this evidence should have been looked at. There's no question about it. Which is why, of course, in the end, it ultimately was. But what you're seeking to elicit from me is assistance on whether or not, effectively, guidance needs to be given to the Rules Committee for them to consider whether or not they should adopt a position of applying the overriding principle, and therefore, effectively, many of the criteria which are incorporated within the rule, before considering whether or not, or when considering whether or not there's a reasonable explanation or whether or not there's promptitude. And my submission to that is that does not apply, and more particularly, it should not apply, because once you've passed those two factors, the threshold criteria, which is part of the justice process itself, there is built within it the ability under 3A for the court then to go on and consider the justice and the prejudice and so on. And there are criteria which are laid out there. It's already incorporated within the rule. It doesn't need some superior rule for its further interpretation. Lords, may I turn to the chronology? I'm going to go through this descriptively as far as I can, but there will be some pages which I'll invite you to look at specifically. The claim form to begin with, if you'd be kind enough to look at 173. This is back in 2013, and in particular the points I'd invite you to look at are E, which you've seen before, but the assertion of a matter of material fact that at approximately 3 a.m. the membranes ruptured, and turning over to 174, G and H, at approximately 4, the second defendant arrived, and Mrs. Balwah was taken to the delivery room, and H, between the hours of 4 and 5, vaginal delivery was attempted without any progress. Now, those were specific and discrete, separate statements of material fact. There was a joint defence of that in the September of 2013, which you'll see on page 187. And if you have it at 187, you see that there's an express and quite clear admission of the paragraphs I've referred to in paragraph 21. In particular, the 4 and the 4 to 5 by Dr. Abdulla. Now, a little while after this, in September of 2013, there was the first CMC. This is to be seen in the judge's judgment when he was determining the interlocutory matter. And it's important only because, of course, in order to fit within the requirements of the order, any amendment after the first MC had to go through this process. And this was clearly after, I'm sorry, my Lord, after the first CMC. I'm just saying that that bracket, there was argument in one case as to when it applied, but it's November 2013 through until February 2014. At this time, the docketed judge was Madam Justice Carol Gobin, and she had the control until shortly before trial. And part of that control was to order the exchange of expert witness evidence, which occurred about 13 months later. And that expert witness evidence came from the claimant, Aeden, in the form of a report from Dr. Jayasimi and a radiology report from Dr. Forbes. At this time, the defense was a joint defense, and they jointly relied upon an expert in exchange for those expert opinions which had been served by Aeden. From a Dr. Prakashban Prasad, it was a one-page report. It's not in the bundle.
Sorry, what was the name?
Prakashban Prasad. It's not in the bundle, my Lord.
Dr. Prasad.
But neither party relied upon it. There then came a change of attorney. The defendants decided that they would separate. And so far as Dr. Abdulla was concerned, he instructed Aeden Balwah, a senior counsel who's known to this tribunal. And then there was an application to amend, which was made by the claimant, Aeden, in October of 2015. Now, there's nothing relevant for the consideration of your lordships on this. It wasn't opposed. It incorporated allegations of vicarious liability and various aspects of the misuse of misoprostol, because this had evolved as a consequence of the opinion of Dr. Jones. But nothing turned on it. But it enabled a permission to be granted for further expert reports. This is in 2015. And enabled the claimant to amend the statement of case. And if you turn to page 226, you will see that the amendments, now we've moved on from the assertion of these material times in 2013, 3 years to 2016, and the assertions are exactly the same in paragraph 18. You'll see it in E and overleaf on 227 in G and H to the ones that were made 3 years earlier. Now, something happened. Now, that was filed in February 2016, which is very material to this case, which was that what was termed a secret statement was made by Dr. Abdulla, and it's to be found at pages 760 in our bundle.
76.
760, my lord.
760. Thank you.
There are several pages here which you may wish to look at, but this for the purpose. In February 2016, was shown to and relied upon by Dr. Wilkinson and Dr. Sinkelman. And this, besides identifying, as you see on 760, the time of os fully dilated at 4:30, went across onto the following page. It is said an advocate should never be embarrassed about advancing a point, and having said that, I suppose I am somewhat embarrassed in doing so. But as you will see, and you've had your attention drawn to it in the written submissions, this document recognised through Dr. Abdulla, of course he's not the expert for these purposes, but the conflicts that appeared in the notes and the expert evidence which at this time they'd had from the claimants through Dr. Jayasimi and Dr. Forbes for 7 months. So they had the claimant's case in advance for 7 months, in which it was made apparent that with a timing of 4 o'clock, which is to be remembered, at this stage was admitted by all the parties, was going to be prejudicial on the question of, in particular, prolonged second stage.
Why?
The importance isn't...
Sorry, why?
Yes, isn't so much what Dr. Abdulla thought about it, but this is Dr. Abdullah's evidence on timing. And despite that evidence on timing, we didn't know. I mean, just to leap ahead, that note was not finally produced by Dr. Abdullah's team until after all of the evidence in this case on the last day of trial.
Sorry, which note?
The note you're looking at, what I've termed, perhaps less pejoratively, shall we say, undisclosed note of Dr. Abdulla at page 760 and 761.
Isn't 760 just an abbreviated form of the medical notes and records?
Well, it's...
Isn't
It has to be taken as a whole. I'm not seeking in any sense just simply to extract one of the several pages that there are here, because it will take time.
Is there anything secret about what's on page 760?
No, there are statements of fact there which are contrary to the pleaded admissions.
And these all appeared in the witness statement, which was lodged later in 2000.
They did subsequently, but...
Well, a few months later.
Yes. Yes, I'm almost there. I know that you're pressing me on it all the time.
I'm just wondering what the significance of this document is.
Well, the significance is knowledge on the part of Dr. Abdulla and his team.
Well, you don't have to go to that. All you've got to do is go to the notes he himself made.
It's knowledge of the recognition that if the timings were right, then there would be a prolonged second stage.
Well, I don't see where that comes from this document. Perhaps you can talk me through it. He sets out the timings.
This is
where does he say, look, you know, if it's 4 o'clock to 5:30, then, well, that's a long second stage.
It's 4 o'clock to 6:15.
Right.
My Lord, the Court of Appeal did fall into error over talking about the 5:30 end for second stage, because
Yeah, I do.
there are numerous references in the judgment and in the submission.
Yeah.
Second stage lasts from full dilatation to delivery.
Yeah.
And that's either 4 o'clock to 6:15 or 4:30 to 6:15. It was an error, but we would submit, as we have done in the written submissions, it's an immaterial error. Just to continue this important chronology, and I will get to Lord Doherty's point in just a moment. I know that he's pressing me for it. There followed in March, again, the state of play as all these times are admitted, there followed in March the expert opinions from the clinic. This is on the 18th of March.
So which year are we in now?
We're still in 2016.
Yeah, thank you.
And in this, they produced 2 expert reports of Arun Naring Singh, and I'll give you a reference to it, but his report, he's an expert on private hospitals, and the relevant part is on page 1072. And he simply said the doctor was on site at 4 o'clock in the morning. And their consultant obstetrician, Dr. Sad, at 1075, who said at 4 a.m. contractions of 1 in 5, cervix fully dilated, start of second stage of labour. Now, look, both of these experts were looking at the notes. The clinic is looking at the notes through their experts, and both of them are, so to speak, identifying 4 as being the start of this process.
But are they doing any more than just reciting the evidence which they've been given? In other words, setting out the factual basis upon which they will later express expert opinions. Reading a note that says 4 o'clock and saying in your report 4 o'clock isn't a matter of expert opinion, is it?
Well, I would agree. It's not a matter of expert opinion. What is happening here is that there's a sequence of those that have come to look at the notes. Now, putting aside Dr. Abdullah's retrospective interpretation of what 04 means, as being full dilatation and Dr. Abdullah being on site.
That's your reading of it. I mean, these witnesses didn't give evidence. They weren't questioning their interpretations.
Yes, but that's exactly what's happened, because it goes back to what is the material evidence in this case that anybody can rely upon. It certainly, as the judge found, it's not Abdullah. Forgive me, Dr. Abdullah. It's because the lay witnesses were not accepted as being reliable. And if I may, there's a very important point in respect of the lay witnesses not being found to be reliable. The lay witnesses were cross-examined contrary to the admitted pleadings of both defendants, because those pleadings were not changed until the 6th day. Their evidence was challenged contrary to the admissions. And inevitably, in our submission, a judge is going to look at the way in which these witnesses are reliable in the light of that cross-examination, when that cross-examination should, in our submission, because of the pleading point, have never arisen. Dr. Alsayed also, in his report, in respect of the notes at 437, which we've looked at, could I invite you just to look at 437? Dr. Alsayed, in his expert, and he's the obstetrician, he's doing the exercise here that Professor Dr. Jayasima is trying to do as well, to interpret the records. And in the end, the interpretation of the records depends, in the end, in our submission, upon the expert evidence as to what they're saying. And he interprets this record here at the bottom of 437, 1 to 3 moderate, as being the record of the contractions at 4:30.
At 4?
I'm so sorry.
At
thanks,
4
thanks,
o'clock.
thanks, very important.
Sorry, at 4 o'clock.
At
yes.
4 o'clock, yes.
But he also went on to say that the cervix was fully dilated.
Yes, he did.
Based upon that record, that note, there's nothing about the cervix being fully dilated.
No, there isn't. But there is Dr. Abdullah's own note, which is already interpreted. So in other words, what he has done in our submission is that he's looked upon that note of the record of contractions and has added it to his interpretation of when full dilatation took place. But the upshot of this is that the clinic were left with a situation when both of their experts had effectively accepted the interpretation which we had all placed until this time, except Dr. Abdullah, because we were unaware of that statement of February 2016, all interpreted as it being 4 o'clock. And when it came round for them to do their amended defence, which they did, they also accepted fully the allegations, or the assertions, should I say, of the timings. And would you kindly just look at the way Surgi-Med did it? It's page 260.
260?
260, yes. So the first defendants, the clinic's amended defence, and you will see that paragraph E, in answer to paragraph 18E of the first defendant admits the claimant's mother's membrane is ruptured at 3 a.m. Now, this is actually quite an important assertion because in the joint defence, the trial judge got this wrong. In the joint defence, they looked at the notes and they said, well, actually, the notes say 4:30 and we're not admitting or denying it. But now move on 3 years with the benefit of experts. They identify and admit, they change a sort of non-admission after 3 years into an admission. And this admission of membranes rupturing at 3 is quite contrary to their own nurse's entry, which you see on the page I've referred to, 437, where it says the membranes ruptured at 3:30. So not only did the learned judge at trial find that Nurse Hosson's notes were at fault in respects, here's the clinic, after expert evidence and further consideration and amending their defence, contrary to their own nurse's entry, admitting 3. They must have thought about it because they changed it. They must have known of this entry because it's their entry. So the question arises, we don't have an answer to it, is why should they go against their own nurse's entry at 4:30? In our submission, it's because 3:30, I'm so sorry, that entry is unreliable. So here we are, March 2016, and no sight of anything being wrong with the way over the 3 years and with this amendment and the clinic's address to the amendment, no change at all on the admissions of these timings. And then Dr. Abdullah's reports appear in March the following month. 7 months, as I said earlier, from the time that they were alerted through the claimant's reports that a timing of 4 o'clock was going to be problematic for them. And through those reports of Dr. Sinkhorn and Dr. Wilkinson, they rely quite plainly, and say so, upon this note of which we were still unaware at that time, of 4:30. So that is the first time that the other parties, obviously including Aeden, were put on notice that something contrary to the admissions was beginning to emerge.
This is September 2016.
No, this was April 2016. March, 31st of March 2016.
That was March.
When the reports of Dr. Abdullah, Dr. Abdullah's experts, Dr. Sinkhorn and Dr.
So 6 months before the witness statement.
Yes. Yes, I'm very conscious of the point that you're addressing, Lord Offerty. Now, remarkably, the second defendant amends.
The second defendant, yes.
The second defendant, Dr. Abdullah, amends. And if you look at page 278 to see that amendment.
Sorry, page?
278.
Thank you.
And at the bottom of 278, the paragraph numberings in the amended statement of case change, but the point's the same, they can be followed through. They're admitting Dr. Abdullah arriving at 4.
Well, approximately 4.
I thank you for the correction. And they're admitting that, which is more important, they are admitting the fixed time of 4 to 5 for attempted vaginal delivery. Now, this is notwithstanding the undisclosed note back in February, notwithstanding their expert reports as disclosed in March, they're still making this admission. But my learned friend has drawn attention to an aspect of this pleading which he, in his submissions, asserts produces lack of clarity. It's in a very long paragraph, which starts, for these purposes, on page 292. 34.21. The notes indicate that this was continuously monitored until the claimant was, forgive me, fully dilated at 4:30. So that's one conflict with the admission which was made earlier. And the second conflict appears on the second page, which is 293. Paragraph 15 is not relevant in paragraph 34.23. The relevant part is the second part of the sentence. The second defendant was summoned when the contractions were moderate to strong and Mrs. Balwah's cervix was fully dilated, which turns to my Lady Rose's point on full dilatation and the attempted delivery. Milady, if Dr. Abdulla is right in this amended defence, that he was called when Mrs. Balwah's cervix was fully dilated, that fits with a timing of 4 o'clock.
But it also fits with the timing of the attempts starting at
Yes,
4:30.
yes, it does. But yes,
And on Dr. Jaimesimi's
Yes.
account, you
Yes.
can have a passive stage of second stage labour and then an active stage, because he talks about the 1 hour and the 2 hours.
Yes, indeed.
So does it help you if full dilation was before 4:30, but active attempts at vaginal delivery didn't start until 4:30?
Yes, if I may say so. It's a very astute observation, but the timing of starting at 4 and running through until 6:15 is material on the issue of whether or not there was a prolonged second stage. Because second stage does not take into account whether there's a passive phase or not. And there is a passive phase, but there wasn't from the time at which the attempts were made by Dr. Abdulla. The issue of the description, and maybe I find it in a moment, the description of Dr. Abdulla of the second stage relates to his interpretation of this being the active part of second stage. So what we're talking about is, maybe I can address it another way. From the time when the attempts were made,
Yep.
Dr. Abdulla is saying that is the active stage of labour. But from the time of whether it's a prolonged second stage, not an active stage, prolonged second stage, runs from the time of full dilatation to delivery.
Sorry, it runs from?
The time of full dilatation, my lord, at 4 or 4:30 or whatever, and whatever the issue is on that. But the issue here, in this amendment, is that Dr. Abdulla is saying that he was called at the time of full dilatation.
Yeah.
I mean,
Could you just possibly give us the reference again to Dr. Jaisimi's report? Mr. Strang referred to it about the prolonged second stage and the active and passive
Yes.
phases. I can't
yes,
immediately
my lord,
find the page number.
in our written submissions, we have appended the submissions that we made to the Court of Appeal as part of the reply submissions. And you will find those, the submissions that were made to the judge on 2817. So there are a few pages there which set out exactly the point that you're asking about, my lady, and it sets out the definition, the timings, and so on. There are just a few pages which we've appended to deal with that.
See, Dr. Jaisimi said that the second stage should be no longer than 3 hours, 1 hour passive, 2 hours active.
Yes.
And then further up, it's the stage of active pushing that shouldn't normally exceed 60 minutes.
Yes,
And we're all agreed that it's 60 minutes is the issue.
Whatever other agreements there are, the active pushing phase is agreed as being an hour.
Mm-hmm.
So that didn't infringe in second stage a requirement for active pushing. But it doesn't help, of course, in respect of timing. Because what we're looking at the moment is a correlation between moving Shelly-Ann Balwah into the delivery room when she was fully dilated. And the issue there is whether it was as agreed at 4 o'clock or not. Because that is the timing when this process is taking place, when the start of the prolonged second stage takes place. Now, given these conflicts here, in particular, internal conflicts to the amended defence, in paragraphs 34.21 and 34.23, each of us alluded to, it came the claimant's chance to reply to this amended defence. And I think I'm probably getting around to Lord Doherty's point at last, which is pointing out in the amended defence that there are conflicts here, because it must still be remembered, we have, at this stage, had no sight of any reason other than that was incorporated within the disclosed reports. There are conflicts between the times which are put in the reports and the admissions. And effectively, in our submission, unequivocally, through the course of this, it penetrates various parts of the reply. The assertions are remade as the times. The assertion is made in the reply that there have been admissions to these times. And the assertion is made in the reply that the expert reports which have been relied upon are not relying upon a proper factual basis. Now, in our submission, that comes as close as one can say, because we still haven't got the statement, all we've got is the expert reports. This comes as close as we can say to, wait a moment, what you're saying through your defense now and your expert statements is contrary to the admissions that you've made in it. So effectively, not only are we pointing out in this submission that conflict of fact, but we're effectively putting them on notice that this needs to be resolved. We haven't said so, it's a pleading after all. It's rather a lengthy pleading, as many of these pleadings unfortunately are. And then we come down to the statements.
I just wonder if you could show us in the reply to the amended defence.
Yes.
I don't think we've looked at yet.
Certainly.
Precisely which paragraphs
give you some references.
You refer to, and
yes,
particularly where either directly or inferentially you deal with the 34.21 and the 34.23 points. I think it's at page 299. Or
a little bit further on, 319.
319, thank you. Ah, yes.
So, at paragraph 26 in the reply, the claimant denies this paragraph 34.18, the amended defence, and states the following: by the admission of the second defendant in paragraph 22, the amended defence, the second defendant, this is a reply to the second defendant, vagina delivery was attempted between 4 and 5. That removes the approximate point we were talking about earlier. The decision to do a caesarean section was not made until 5:30. This incurred an initial delay of 30 minutes. And then a little further on, if I may, probably the short circuit to this is to turn to 324. And a paragraph 44. 324, paragraph 44. There were in the amended defence 2 paragraphs 36, but that's just a typographical error. But it's the first of the 2 paragraphs, 36, which relies upon essentially the expert evidence. Okay. So we say in response to that, the claimant affirms that several of the opinions and analyses of the expert reports referenced are based on factually inaccurate statements or notations from the second defendant. So this reply has said, look, you've made these admissions, we reassert them, and references the implications that the expert reports are on a false basis.
And then I think you deal directly with paragraphs 34.21 and 34.23, on which Mr. Strong relied in your paragraphs 29 and 31,
Yes.
page 320 and 321.
Yes.
Which essentially join issue on the facts, I think. Is that a fair way of putting it?
Yes. Yes. Now, an issue arises as whether we should have, when this statement was served and when in due course evidential objections were taken, as to whether we should have said, sorry, the statement of Dr. Abdulla conflicts with the pleadings and it ought to be struck out. Maybe there's an argument for that running, but it is certainly not an argument for admitting it, given the pleaded position and given the opportunities, of course, plentiful opportunities, that the second defendant, Dr. Abdulla, had to amend the pleading to pull it in line with the 4:30 timings. And besides, Lord, this is in the context of a situation where we all know that a witness statement is not evidence. We know that a witness statement, and I made reference to this earlier, a witness statement cannot amend a pleading. We know that a witness statement may never be relied upon. We know that it doesn't become evidence in the case until the witness is sworn to attest to that statement in the witness box. And what was happening even before that stage had taken place, on the admissions, in the first 6 days when this was going on, there was a cross-examination in relation to something which hadn't been put forward as evidence in the case, but simply in a witness statement. It had been put forward on the basis of expert reports to which exactly the same applies until those experts give their evidence. And when they do, the challenges were properly raised that these were contrary to the admissions which had been made. My Lord, retrospectively, do I regret at the time being involved in this? When this had happened, I hadn't insisted that the right process now was for the judge to consider requiring Dr. Abdullah's counsel to make an application to amend. Because there can, in our submission, be no issue at all about the importance of this timing. The whole of the experts' evidence, it really is an apples and oranges situation. Experts will differ, of course they will. But our experts, for Aeden, were focused upon the 4 o'clock timing. And all the times, the years which went by thereafter, their reports, both of their reports, including the supplemental report, were served at a time when there was no quibble about 4 o'clock and 4 to 5 being admitted. So the situation now arises, which is very, as I say, and I don't apologize for repeating it, it's very comparable to the situation which was arising in respect of the scan. This is potentially a very critical piece of information. It's such a critical piece of information, it became the paramount factor on which the court decided it would determine the underlying issue. And the underlying issue is, was this injury before the delivery process, when no one, as the judge cited, Dr. Wilkinson and everybody agreed, it had been before duties arose in respect of the management, then the claimant loses. But if it were intrapartum, given that long period during which the fetal heart rates would have been abnormal, the question then arises, the only way that you detect this is through monitoring and recording, and there's no monitoring and recording. Now, did you find that? Oh, thanks. My learned friend Mr. Strang relied upon a criticism of the Court of Appeal in their failing to consider the whole of the paragraph, as he put it, to turn the page over. If you remember, in respect of the timing. The reason I'm addressing this is because it's being advanced that there was evidence in the papers that there was a normal fetal heart rate at 5:30 when the decision was made for a caesarean section. Now, could I turn you, I hope to, I'm going to go, maybe we'd just very briefly look back at the notes themselves to 437. You've seen these once or twice already. And then if you turn over the page, there's a certificate. And then if you turn over a page one more, there's a note about 4:30. And then 441 is the entry which we're looking at the moment, which is the 4 a.m. notation by Dr. Abdulla. And then there's the operation note on 442 and some other notes. The embarrassment of not being able to find where it is on the subsequent page. I'm sorry? 442 very top. Thank you very much. That's very kind. Thank you very much. Yes. And thank you to Mr. Brown for referring me to that. 442 at the very top. Now, this note is being advanced as though the caesarean section is being determined, and at that stage, there's no abnormality of the fetal heart rate. But the judge, in his judgment, if you go to paragraph on page 81, and look at paragraph 143, he distinguished these two notes. Paragraph 143 of the judge's judgment, he says, the next entry has a time of 4 a.m. This is the entry which is in dispute, where it is said, called out to see patient is fully dilated, vaginal delivery attempted for 1 hour without progress. Fetal head descended to, it should be the level of the spine, and no mucanium stain like or fetal heart rate, regular, then it's illegible. And then the judge says, and another note with a timestamp of 5:30. The notes, not the note, the notes themselves don't really assist the court. But the point, my Lord...
Determining what the 4 a.m. timestamp. You read that short.
Yes. Well, it wasn't intentional. It certainly wasn't intentional. No, it doesn't. Yes, exactly. But I'm addressing the issue of what reliance can be placed upon an interpretation of notes which the judge has determined are separate notes. They are physically separated. And what the learned friends is seeking to advance by way of submissions is that this is evidence that there was a normal fetal heart rate recording at 5:30.
Well, it must have been after 4 o'clock, and it must have been after
Yes.
the
Yes. Yes.
attempted for 1 hour.
Yes, my Lord.
And
We have obviously...
well, it could have been before the episiotomy.
Yes, my Lord, a fair interpretation, and by fair I mean conscious of the fact it can be interpreted another way, is that that note, first note as I shall call it on 437,
It's a running commentary.
is running evidence of a normal fetal heart rate at the end of the hour's worth of attempted delivery. It's not, in our submission, evidence in support of a normal fetal heart rate at 5:30. And
that really depends on you persuading us that there ought to be a break between the foot of one page and the top of the other.
well, it depends, surely doesn't it, my Lord, upon how the judge, with the benefit of all this evidence, looks at that note. which in the end he doesn't find to be helpful on 4 o'clock. But
I'm sorry to interrupt. You say it's not evidence of a normal fetal heart rate at 5:30.
yes,
So what is it evidence of?
it's evidence of a normal fetal heart rate sometime after the note at 4. And looking at the description and the sequence of that note at 4, which includes the hour of attempted delivery, we would fully accept that it's evidence of a normal fetal heart rate at 5 a.m.
But why 5?
Because that's after the hour of attempted vaginal delivery. It's either, that's the latest in our submission that it can be.
It seems to me to be, I mean, it's based upon a note which proclaims that it's 4 p.m., a.m., sorry, and refers to a whole series of matters that occur after 4 a.m. and with absolutely no evidence, or no conceivable way of giving evidence as to when the note was actually made. The note could have been made at any time.
Well, it could, but I've sought to put the least favourable interpretation upon that note from Aeden's point of view.
The least favourable interpretation from Aeden's point of view is that it's 5:30 that what's being described ends.
If the proper interpretation of that note is a normal fetal heart rate at 5:30, then there isn't sufficient time until 6:15. The claimant's assertions, as admitted, are that this process of active second stage facilitated, encouraged delivery finished at 5, as was admitted.
Well,
and as
I just have some difficulties. I mean, all this has gone into at a trial. Very conscious not there. Don't know how the evidence is presented. But is it not the case that you can get fetal distress shown by an abnormal fetal heart rate? The fetal heart rate can recover and then be under stress again during the course of contraction.
Yes.
So a one-off fetal heart reading, normal fetal heart reading, doesn't exclude there being distress.
No.
But it appears to have been run on the basis that it does, because you say if there is a normal fetal heart rate at 5:30, then not sufficient time up to 6:15. And so, I mean, you know, but it's not our role to decide the facts. It's not our role to inquire into that. So I just have, you know, the opportunity for doing all that was at the trial.
Yes, it was.
I mean, there's a normal fetal heart rate at 4:30. There's another one on this one, potentially at 5:30. The caesarean section's carried out at 6:15. And the judge concludes that there wasn't a 1 hour period.
Yes. Lord, the evidence of Dr.
That's the reason why you have an actual record being kept. I mean, the idea you put a Doppler on and you listen without keeping a record of it could have been advanced at trial. It could have been a finding by the judge at trial. The whole purpose of a record is so that you can see these variations and see the variations when the contractions come and so on. So we don't have that evidence.
No,
the trial judge
there is a dearth of recorded evidence, which of course it was a finding of the judge, was an obligation upon the clinic to do from the time that mother and baby or fetus were admitted until the time that they were discharged, to record what was happening. And
do we proceed on the basis that if there's a normal fetal heart rate at 5:30, then there was not sufficient time up to 6:15 for there to be hypoxic injury to Aeden?
No, Lord.
Well, you've just said that.
You just said we did.
Well, there was a conflict over the evidence as to what monitoring was taking place, and you appreciate that there's material here which everyone's been trying, including the trial judge, to interpret.
No, it's a very difficult case.
The evidence of monitoring after every contraction during the attempts was not accepted by the judge because he didn't place reliability in the absence of anything that was recorded. Obviously, if there had been monitoring through until 5:30, if there had, and Dr. Abdullah's evidence had been accepted on that, and the monitoring was normal, then there would not have been enough time between 5:30 and 6:15 for this injury to have occurred. No question about that. But if the timings were as admitted between 4 and 5, even if there had been monitoring, but no monitoring after 5, there would have been enough time for this injury to have occurred between 5 and 6:15, 75 minutes. So in our submission, the timings were critical and became critical. This is why the judge determined that the way he was going to resolve this was only through the timings. Just the paragraph 136, my lord, which I believe you were referring to.
And when did it become critical? You say the timings became critical.
Yes.
When did it become critical? When was that issue, that critical issue, identified?
I can't give you an answer to that at the moment. I should be able to, but I'm afraid I can't. Yeah. Can I explore this with you, my lord? When the judge at paragraph 136, which I believe you attributed to a discussion about the misoprostol, set out the criteria that were relevant there, such as the APGAR score, it became apparent that the experts, they interpreted the APGAR score in different ways. Dr. Wilkinson was prepared to accept that there were signs of hypoxia, which could be consistent with, but he was against it, of course, intrapartum injury. So it became neutralized, the APGAR score, as a means of the judge determining this issue. The principal issue was intrapartum or not. The APGAR score wasn't going to help. And the scan, which had been thought possibly to resolve it, didn't, because Dr. Wilkinson changed his position on the significance of the scan once it became aware that it was abnormal through the joint report, which Lord Doherty made reference to. So it couldn't be resolved on that basis.
In layman's terms, I'd have thought the APGAR score was highly crucial evidence, insofar as if this child had unfortunately received the most severe traumatic brain injury just moments before birth, the APGAR score would tell you something about that. You obviously get a low APGAR score at 3, but it recovers.
Yes, but the experts differed in their interpretation of that APGAR score. And they both accepted effectively that it can't be resolved. Not only the APGAR score, but the whole interpretation that the experts were giving on the neonatal evidence, which required a consideration of all the clinical circumstances, differed. And their differences couldn't be resolved. In the end, Dr. Wilkinson, in his evidence, accepted that the only way really to resolve it was was there enough time for this to have happened or not? That's how it emerged as an issue, because the fetal heart rate monitoring also could have resolved it. If it had been monitored, if it had been found to be normal, that would be it. There wouldn't be a case left. But in the absence of adequate and proper fetal heart rate monitoring, the claimant couldn't rely upon the absence of evidence, and nor could the defendants effectively rely upon the absence of evidence, as they say, as evidence of absence of fetal heart rate. It was just a blank. So these three features identified in that paragraph 136 that were going through the judge's mind, not one of them could resolve this issue. And in the end, it was by agreement between the parties that it would resolve the issue.
But was the agreement that it could resolve the issue one way, or was it an agreement that it could resolve the issue both ways?
It was an agreement.
The submission from Mr. Strong is that it was only one way, and that the whole question of causation was left open because the judge decided that it was resolved against the claimant.
Well, that is a critical matter for the determination as to whether there was an agreement or not. And
well, it's not referred to as an agreement by the Court of Appeal. They say in short that it's only in a short, I think 1.5 sentences, but it follows as night follows day, I paraphrase, that if it was longer than an hour, then causation is proved. They didn't suggest that there was an agreement that that was the case.
I think that may be wrong, because I think they talked about the agreement. And again, I'm going to have to find this reference in a moment. But during the course of the submissions that were put forward to the Court of Appeal by Dr. Abdulla, I hope somebody's going to prompt me about the page in a second, but it was between paragraphs 8 and 10 of those submissions. At the moment, I don't have the page.
Whose submissions?
These are the submissions on behalf of Dr. Abdulla to the Court of Appeal.
I think we did look at those this morning.
Yes, we looked at some of them. That's quite right.
Quite explicit that causation would be resolved one way, but not the other.
My Lord, with respect, that's not the way in which that was advanced. We didn't look at the agreement which was contained within paragraph 8, as set out by Dr. Abdulla, who presented...
Which page are we looking at now?
Well, yes, I'm sorry, I don't make reference to it. Submissions to... excuse me a second. Submissions to... It's paragraph 8, when we finally get round to finding it. I'm so sorry, I don't have it to hand at the moment. But when we see it, we will see that there are a couple of, in those paragraphs I've mentioned, 6 through 10 of those submissions, twice we see that there's an agreement of resolution, that this would determine whether or not the injury was pre-partum or antepartum, and it would determine whether there was negligence or not. I'm sorry, I can't immediately.
2497.
Yes, I should remember this page. I'm abreached. Thank you very much. 2497. So it starts really at paragraph 2496, at paragraph 7. These paragraphs are fundamental not only to the position as recognising what had taken place at trial, but more particularly in presenting this case to the Court of Appeal. Because in the end, the Court of Appeal had to determine the matter on the grounds of appeal, and of course there wasn't any counter notice and so on. but they had to determine, in the light of what it was interpreted to be the situation, paragraph 7, during the trial, the parties all agreed to a qualifying factor in determining if there was negligence or not. Aeden was delivered at 6:15 in the morning. Dr. Abdulla claims he arrived at the hospital at 4:30 a.m. and hence it took 1¾ hours to deliver the baby, with 1 hour being active labour before the decision to do a C-section. The appellant claims Dr. Abdulla arrived at 4 a.m. and hence the delivery took 2¼ hours. And then paragraphs, and this is important, but I won't waste time trying to read those paragraphs which are referred to there, but they're worth reading, 139 and 146. And then at 8, there is a factual discrepancy of half an hour between Dr. Abdullah's and Shelley's recollection. This difference of half an hour was agreed between the parties to be of critical significance as to whether the 1 hour of damage occurred intrapartum or prepartum.
If one goes to the executive summary of the foot of page 2498, the very first paragraph.
Yes.
Paragraph A, the parties agreed that the court had to determine if Dr. Abdulla arrived at 4 a.m. or 4:30 as a precondition to determining if it was possible that the cause of Aeden's condition was due to negligence or not. Not
yes.
Whether the cause of Aeden's condition was due to negligence or not.
Given the time, and given that I have only 10 minutes left, yes. May I just address the significance of what is taking place here? That in the speaking note, which was presented to the Court of Appeal, which you will have in a separate bundle.
Yeah.
Yes, we do.
The second supplemental bundle.
Second supplemental bundle. You'll see what's being advanced by the clinic.
At page.
Moment again.
I think the clinic starts at page 7, possibly.
Yes, that's right. And if you move on to page 17 of that bundle, you'll see the way in which it's
So we're talking about the internal numbering of it?
I'm talking, no, not the internal. The bundle is actually numbered, my Lord. There's the index, the supplemental bundle. The internal page is page 7, but the...
So the second supplemental bundle, page 38, internal number 17.
No, 16. Internal number, page 10.
No, I'm sorry, we're not on the same wavelength.
You should, my lords, have
the document,
the second
the document is the appellant's speaking note.
It's the speaking
yes?
note, yes, indeed.
Which is
the second supplemental bundle.
The appellant's speaking note is item 3 in the bundle?
It is, my lord, yes.
And we're going to...
We're going to page 10 of it.
Which is on the electronic page 16. Is that right? And paragraph. Let's get the paragraph.
Well, could we go to the paragraph numbers of the speaking note?
Yes.
I apologise for the...
Not at all.
This came in late, but nevertheless it's important. What is being submitted here in this?
Sorry, which paragraph are we going?
I'm looking at paragraph 6.5.
I think well, certainly I'm in the wrong document. Then whose speaking note are we looking at? Is it the appellant?
Surgi-Med's. Surgi-Med's response note to the Court of Appeal, served on the 7th. Yes. Yes.
Thank you.
Yes. Internal 10.
So it's tab 2.
It's tab 2.
Yeah, tab 2, page 16.
Page 16, paragraph 6.5. 6.5.
And the relevant parts of this is on the supposition that the Court of Appeal were right to find a timing of 4. In other words, the pleading point. They then go on to say further action has to be taken, further steps. You see 6.41, whether it's damaged has actually caused in the relevant time, and whether or not there's consequential breach. At the bottom of the page, no decision was reached, and overleaf.
Sorry. Oh, yes. At the bottom of page 10, internal numbering.
Yes, no decision was reached. And then overleaf. The first respondent seeks to demonstrate that there's a very substantial dispute on the expert evidence, and so on. Accordingly, if the appeal succeeds, it's on timing, it will be necessary either for this court, the Court of Appeal, to determine this issue, or for there to be a retrial. Now, in our submission, my lords,
well, to make sense of that, we'd have to know what issues 1, 2, and 3 were.
They related to the finding of time. But the problem with this situation is that this was simply not put before the Court of Appeal in an adequate format. It wasn't addressed by the Court of Appeal. It wasn't contained within any of the oral submissions on behalf of Dr. Abdulla, or by Surgi-Med in argument before the Court of Appeal. So far as we know, we do not have the transcript. But the Court of Appeal didn't address it. Now, the fault there, we maintain, is that there was a failure to serve a counter notice.
Well, what was the need for a counter notice given what the trial judge had said in his paragraph 147, where it made it absolutely clear it wasn't necessary for him to take the further step?
Because, my lord, is that the defendants wanted a different order. What they wanted was an order for the judge's judgment to be varied, because, of course, the judge didn't expressly reach this conclusion, although our submissions, which I'm sure you will read in due course, set out why it was that the timing issue became the critical, and we say the determinant part, and the agreement that it was in accordance with Dr. Abdullah's own counsel to the Court of Appeal through that note.
Well, tell me something. The judge says, I'm not going to decide that issue. It's not necessary because here's another issue, which is fatal.
Yes.
And that was, you say, contrary to the agreement between counsel. Well, why didn't the appellant appeal? Why didn't the appellant say, the judge has got it wrong? Everyone was agreed that if there was a 1 hour period of time, that was sufficient. That was causation established.
Well, to answer your question with another, effectively what the defendants were doing, or the respondents to the Court of Appeal, was to say, yes, there is another defense to this case, and that's that even if the 4 o'clock is determined, it only determines that it could have occurred, the injury.
That's right. That's what the judge said.
Yes, but there is another defense to it,
And
namely that, yes,
another defence which hasn't been adjudicated upon.
which hasn't been adjudicated on precisely. And the time for that adjudication, my Lord, was before the Court of Appeal and through a counter notice. It's the very purpose of the counter notice, because in the same way as the requirements of a notice set out exactly what it is that is required, why it's required, what's gone wrong, and very particularly the orders which are required to be made by the Court of Appeal. And this is a situation where the respondents are seeking to raise, for the first time effectively, or trying to be effectively before the Court of Appeal without doing the counter notice. In our submission, this above all mandated it, because effectively it's a submission that the judge didn't do his job, he didn't reach finality, he didn't look at the counterfactual, because the counterfactual has now got us an enormous amount of mess. Our submission is that there was never a counterfactual, because it all crystallized into the agreement which was put forward to the Court of Appeal between the parties, that the resolution of timing would resolve, whether it's inter partem or not. This was what was said to the Court of Appeal through the written submission of Dr. Abdulla, and that it would resolve the issue of negligence or not. It was a reflection of exactly what that situation was. The 430 would resolve it. And the reason it would resolve it is because the two experts had operated upon totally different foundations. The claimants on a foundation of 4 and continuing because of the admissions, and the defendants on the foundation of 430. So the submission on this is such a fundamental change. It isn't an addition, another ground upon which the judge could have found in favour of Dr. Abdulla and the clinic. This is much more fundamental, that the judge didn't finish his judgment and that an order is required from the Court of Appeal to work it out, resolve this, as we would say, residual causation issue, or remit it. And that may be the reason that we're in this court. And it's not for this court, obviously, to decide that issue. This is an issue which should have been brought to the attention of the Court of Appeal at the time and properly dealt with. And the only way we say that that could be properly dealt with is through a counter notice pursuant to Order 64, because that counter notice would have set out the matters before the Court of Appeal. The Court of Appeal could then have determined whether or not there was an issue of residual causation, could then have either determined it themselves or remitted it. And now we find ourselves years later, 2 years later, in a situation where
and tell me,
this case can't be resolved.
What do you propose? Say for instance, we're with you in relation to the 1 hour period, but we consider that these are outstanding issues. What do you propose that we should do about that?
Well, could I just put forward the difficulties if this were to be... First, we propose that you resolve it. It doesn't require remittal. It can be dealt with by this court.
I thought you told us that we couldn't remit. We couldn't.
Well, yeah. Well, let's work on the possibilities, my lord, if we can.
Yes.
If it were to be remitted to the Court of Appeal, say, for example, it were to be remitted on the question of timing, that this court resolves that the Court of Appeal weren't plainly wrong to hold the defendants to the 4 o'clock timing. It would have to be remitted to the Court of Appeal to consider. Now, they have all the documents, they have everything, they have all the evidence. But the Court of Appeal, of course, on a 4 o'clock timing, would have to exclude all of the evidence which dealt with and relied upon a 4:30 timing. So that would result
in relation to Dr. Abdulla, but not in relation to the clinic.
Yes, certainly. And these experts, of course, were called by Dr. Abdulla, and in our submission, if there had been a 4 o'clock resolution of this, those experts, in the same way as materially were argued on the very days of trial through this case, could not have given evidence on the 4:30 basis. And the defendants' experts were based on a 4:30 basis, claimants were based on a 4 o'clock basis. Lord, I appreciate I'm 1 minute over, and would simply invite you to read the submissions which we believe sufficiently deal with the matters. And that also applies, of course, to the submissions which we've made so far as our appeal is concerned. Simply, one sentence, if I may. If the resolution is that this injury is intra partem, these are completely joined situations. If this was intra partem, the judge's findings in respect of the responsibilities, the duties placed upon Surgi-Med become operative. As we were saying, the duties become operative once no action was taken in respect of what would have required action to have been taken. So if the injury is found to be intra partem, we say it follows in exactly the same format as it does in respect of Dr. Abdulla. Those are our submissions.
Thank you very much. Thank you very much. We'll adjourn now. We'll resume tomorrow morning at 10:30, please. Thank you very much.